Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is what happens after I record my lien and how do I get paid? So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Oh, thank you so much. I do love the name iteration here. So I'm Jessica Murphy. I go by Jess. And thank you so much for having me, Jessie. I love talking to all your customers about what happens after they use you guys, get that lien asserted, and talk about how they're going to actually get themselves paid. So without further ado, let me go ahead and start our presentation. All right, so if anybody on the chat has questions, they can go right into the webinar chat box and put the question up. It'll come up at the end and we'll go through them. Please make sure to keep it vague and don't use company names so we can provide, I don't run myself into conflict issues. Before we get started, I will let you know I am a construction attorney in Massachusetts. I'm going on my 20th year of practice. My father was a contractor, and so after I was born, he decided to open his own construction company. So I like to tell people I could roof your roof, and I can also sue the person who got your roof wrong. It gives me great insight kind of into both sides of what's going on. I've also represented municipalities, large GCs, specialty subcontractors, suppliers, and homeowners. So I see this from all different aspects. Real quick, it's going to be a great 20 minutes. Here's everything we're going to go through. Talk about what your contract needs to have and also best practices for something else to add. Talk about how to secure and enforce your lien and bond rights. Tips and tricks, things that you do need to know about lien and bond rights and how you enforce them, and then talk about the right way to get paid, how to exchange a release for a check appropriately so you don't find yourself in trouble. And then we'll hear more about the SunRay resources and how they can help you as well. So first things first, check your contract. Got to make sure it passes this checklist. One, you must have the proper identification of parties. I strongly recommend that you take a very good look at your credit application, because that could also be your contract if you don't sign other contracts for the work. And a lot of supply houses, that's what happens. The credit app becomes the sole written contract between the parties, and then potentially there could be purchase orders, but more likely or not, there's just orders. If you're a subcontractor and you're doing work, or you're a GC, you may likely have a more specific contract for each project you're working on. But you may also, as a subcontractor, have a year-to-year contract with a general contractor that you're going to work under. The important thing is proper identification of the parties. You should know whether it is a sole proprietor, whether it is an incorporated entity, and whether if they say they're incorporated, they in fact are, or if they've been dissolved. These things are important. A great example here in Massachusetts is if you do work for Cumberland Farms. Cumberland Farms is actually all owned by the Cumberland Farm franchise. Conversely, if you go and do work for Dunkin' Donuts, Dunkin' Donuts has franchisees. Someone may think they have the benefit of working for Dunkin' Donuts and all that corporate dollars, and they may actually be working for a franchisee who does not have the ability to pay. How you can make sure you have the proper identification of parties is once you get that credit app, make sure it is properly filled out, or once you get that contract, make sure there's a full name in there. It's great if your forms have the option to check whether it's a sole proprietor, partnership, incorporated entity, LLC, etc. But if not, go to the Massachusetts Secretary of State's website. You can look right in there, search up either the individual's name or you can search up the company name, and it will give you information about their annual reports, their filing, how long they've been in business, and whether or not they are dissolved or currently active. Okay. Number 2, your contract must also have detailed scope. It's got to identify with particularity what it is that you are doing. If you are a supplier and you are selling supplies, it's a little bit easier. But if you're a subcontractor, if you're doing services for somebody, the scope of work is going to be important. You also need price terms. How much is it and what are they paying for? If you don't have those terms, it is very hard to identify what it is that you agreed on and what they should be paying you for. Last thing is you need to have signatures. The reason these 4 terms are so essential for you is because in Massachusetts, you cannot obtain a mechanic's lien unless you have a written signed contract. It only needs to be signed by the party charged, is how they say it in the law. And so that means it only needs to be signed by your customer. If you have a process by which they send in a credit app that only they sign, that would be sufficient so long as there are signatures. I do also strongly recommend you take a look at who's signing it and make sure you know their name. And if they have somebody witness their signature or however you require it done, make sure they put their name and get people's titles. You want to know who it is who signed for it. Sometimes we have situations in family businesses where one member of the family goes off and does something without telling other people. They don't have authority. So checking the signature, making sure it's someone who has apparent authority to bind the company or someone that you know has actual authority is important. Bonus. Include your payment terms such as net 30 or any other terms that you have so that those are clear. Also include interest if you want to charge over 12%, which is permissible and is the standard in Massachusetts for breach of contract. If you want anything other than 12%, you need to state that. If you want to have fees, those are not provided for by the law. So if you want to have a late fee on past due balances, you must put that in writing. And lastly, attorney's fees. If you don't have your ability to cover your attorney's fees in writing, you cannot recover that under common law. I strongly suggest you put in your ability to recover attorney's fees and costs of collection because it makes a difference when you're looking at trying to file suit against somebody or sense or not. These are the things you've got to make sure those first 4 are in your contract. Here's the additional documentation you're going to want to have for your mechanic's lien in Massachusetts. You want to have the product location. The address is great. Obviously, it's difficult to ask people to put in deed references, but keep in mind if we need to lien it, we do need a deed reference. And sometimes the street address is not the best information, but as long as we actually have a street address and not just saying it's the Ames Plaza, for example, that's important. And the additional documentation you're going to want to also have are delivery details. Do you have signed delivery receipts? Or do you at least have a delivery receipt showing where it's delivered? A mechanic's lien in Massachusetts is only for products delivered to a particular property. And so it is your burden as the person pursuing the lien to prove that it went to that property. You can put things like project location in a contract if you have a specific one, or perhaps a purchase order. And then delivery details would be something that's basically just a delivery on the invoice or some sort of delivery slip that you keep. So let's jump right into lien and bond rights. Securing and enforcing your lien rights. Again, what we just talked about is having that signed contract and knowing the parties on the job. The additional thing that you're going to need for your lien rights is to know who the owner is. That's certainly something that SunRay can help you out with because that deed, looking up the deeds, understanding who's related to things, those we can get. If you do know it in advance, that would be great. Timing is essential when it comes to mechanics liens. They are a creature of statute, and the law says they must be enforced strictly. So you have your first filing is the notice of contract. That needs to come within 90 days of the last date of work on the project. Your statement of account must be filed within 120 days of the last date of work on the project. And then after your statement of account, you have 90 days to file suit. So SunRay is helping you out with those first two items, the recording and the preparation of your notice of contract and your statement of account. Once your statement of account is on record, you then have 90 days from that date in which to have a complaint filed with the appropriate court. So that's what we talk about when we say continue perfection. You continue perfection by filing it in court, and then the attorney would need to follow up and record that complaint with the Registry of Deeds as well. You are entitled to get the value of your lien if you have done this timely. The exception is that it's limited to the amount due at the time the owner has notice of the lien. What that means is that as soon as you provide notice that you have recorded the notice of contract to the owner is then on record as having noticed that a subcontractor, for example, or supplier exists. You take a measure at that point as to how much is left on the contract to pay out to the subcontractor above them, and that is the amount that your lien is limited to. If you were to record your notice of contract at the very start of the project, you can do so before you start to deliver materials or before you start performing services. You can do so as soon as the contract is signed. If you record early on, then you're not going to have an issue with the limit because nobody's been paid. So I would recommend doing that as early as possible. The strongest advice I can give is that your company has a policy that for contracts of a large value, that notices of contract are put on immediately. It makes it much easier from a collection standpoint, your people internally to say we have a process, and for all contracts of this value and higher, we immediately do this. It becomes routine and protects you. I have seen far too many customers not have something in place, talk about whether or not they want to file, and then run out of time. Traps for the unwary about the Massachusetts mechanics lien. A reminder that it's your obligation to prove the materials were used on the property liened. That's where those delivery tickets come in. If you just sold it on a job account, you're going to have a hard time without delivery receipts proving that the materials were used on that property. Please don't wait until the last minute. It does take time to prepare the notice of contract and get those things recorded. So the more time you can leave yourself before those 90-day deadlines is great. If you're going to get paid close to lien deadlines, sometimes checks bounce. If you have not perfected your mechanics lien by doing the next filing or filing a complaint, and you let those deadlines go by because you have a check and the check later bounces, there is no do-over. So if you're going to get paid close to lien deadlines, make sure you get that by wire. And last, be aware that liens cannot be asserted in Massachusetts against public property or against condominium common areas. You can lien for work within a unit because you're liening that unit owner's interest, but if you are liening condo common areas, that is not permissible and those liens will be struck. The good news is, for those two exceptions, we do have, at least for the public property, we do have the alternative. By law, public projects are required to have bonds. They are permitted for private jobs, so if you are working for a condo association, you may want to request a bond to protect yourself. If you have a situation where there is a bond or you know you're working on a public property, go ahead and ask for that, a copy of the bond up front. It's always easier to get at the very beginning of the job before things go bad. Again, kind of say, this is my policy and practice. We always get a copy of these. It makes it much easier to do and enforce, and make sure that you get them. Know your relationship to the bond principal, because if you are a direct contractor of the party that posted the bond, you may not have to give notice. Typically, if you are, let's say, a supplier on a job or a subcontractor or a sub-sub, and you do not have a direct contract with the party that purchased the bond, then you are required to give notice in 65 days of when the balance was due. and then you typically have 1 year to file suit. If you have a direct contract, typically on these statutory bonds for public projects, it's just typical that you have to file suit within 1 year if you have that direct contract with the bond principal. If you have these issues, please let me know, or please reach out and ask questions, because the timing on these is really important. When we talk about how to get paid, and of course the whole purpose here is to get you paid. That's either going to be getting those liens filed, having SunRay do the notice of contract and the statement of account. From there, it goes to an attorney to have suit filed. Once you file suit, you get into general litigation. You typically will then have an attorney representing your company, and there won't, at that point, any settlement is going to be handled in a way that you don't need to worry about your lien rights, because it's being handled all together. The hope is, however, that you can use tools like the mechanics lien, have your notice of contract, have your statement of account go on record, and those are the tools that are going to get you paid. In Massachusetts, if there is a lien, if the product was supplied, if the money is not moving down the chain, but there is money due, the owner has to pay. There are very few defenses to a mechanics lien if the materials were if they were provided to the project and the lien was timely done. So just having a lien on record often brings you to a resolution, because the result of a mechanics lien is that the property can be sold to satisfy the lien, which is great. So when it comes to getting paid, if these work as intended and you get the call to actually resolve it, you want to make sure that you are getting certified funds or a wire to release your claims, especially if it's coming close to deadlines. There is also a high amount of fraud that's happening. You don't want to be caught with that. I always recommend a wire, even over certified funds, because those can be faked. When you have wires, please make sure to have people call and talk to somebody in person to get verification of the wire instructions. There have been a lot over time of hacks in emails that have allowed people to change wire information. But a wire is immediately available funds. If you take a company check, it can take 10 days for you to find out that that bounced. You want to make sure that you review the scope of any release or lien waiver that you are given. There are statutory lien waivers in Massachusetts and a form that can be used. It's not required. And often people will put in broader releases in a lien waiver than is necessary. So take a look at the scope of what you're releasing when you're signing this, because oftentimes you may be signing a lien waiver only to accept payment on part of the job, and you may still be working. You don't want to give up any rights that you maybe aren't aware of at the time. And where appropriate, especially at the end of a job, if you want to be done, mutual releases would be the way to go. They can no longer bring claims against you, and you can no longer bring claims against them. If you're going to resolve it, you should resolve it all in full. I hope this has been an informative 20 minutes.
Yes, this was incredible.
Please let me know.
Well, thank you so much, Jess. You really are wonderful. I do appreciate you taking the time and explaining all the ins and outs to us. There's so many nuances, so we do appreciate it. I do have a question that was posed to me. It says, and I think you already went over it, but it says, if I am not paid after my lien, how long do I have to start the foreclosure process? Are there any documents that are required to be sent before the foreclosure suit?
So and let me just address that a little bit more specifically. The term foreclosure is a little bit different. We might say foreclosing on a lien, but what would happen is that within 90 days of where the statement of account is recorded, that's when suit needs to be filed. The lawsuit then proceeds like any other lawsuit. You're also going to find there'll be breach of contract claims in there as well, but there will be a claim for a mechanics lien. At the end of the day, you simply need to prove what you would for a breach of contract, that you provided materials, that you didn't get paid, that they had an obligation to pay you. For the mechanics lien, you also need to provide that extra proof of that the materials were delivered to the project, which again, it's that delivery receipt and things like that. But that's all part of proving your case at a trial or perhaps on a summary judgment motion. Those are standard things you would also use, again, for breach of contract. Once that happens and a judgment enters, then you're going to have, there will be notices given. And as long as there's equity in the property, the attorneys will start that foreclosure on the lien process or just sheriff's sale pursuant to the judgment.
Okay, wonderful. Thank you for that clarification. Another question that came through, are there any differences in documents or deadlines for residential versus commercial work?
Great question. There are not. And
okay, wonderful.
Yeah, from a collection perspective, one thing that might be difficult is consumers or residential projects, they may not understand the mechanics lien. So that's why making sure that the notice to owner goes out is really important, which is part of the lien process, and that notice can include other things, and making clear that their property could be sold as a result of the lien is very helpful for consumers, because again, they just might not understand what a mechanics lien means to them.
Okay, perfect. And then I believe this is the last question that's come through. Are there any priorities as to when your lien is filed? What if there is a mortgage?
Great question. So in Massachusetts, the standard rule we go by is first in time, first in right. So it all comes down to when you first record. Getting your notice of contract recorded early, that's going to give you the start date of your mechanics lien. So if you record your notice of contract on the day you get the contract or shortly thereafter, you're going to be ahead of any lien that gets filed by somebody else later on in the project. You do at some point have to share proceeds among lienors, but overall, the timing is going to be determined by that first recording. If there is a mortgage ahead of you, it does not have super priority. So it comes in the time in which it's in. You also may have to worry about homesteads and protections like that. When you have a mortgage, there are some times that mortgages may subordinate. There may be cleared. Mortgage companies may also want to clear your mechanics lien to avoid issues. So mortgages are not always bad. I will just say in my 20 years of practice, I have only taken 2 mechanics lien cases to a judgment compelling sale, and neither of those have actually sold the property. Because it's so powerful, people pay is the point there. So hopefully when you get these, you've got either a mortgage company or you've got the owner of the property who's inclined to want to get these things cleared off and pay it up.
All right, perfect. Well, thank you so much. I do believe that's all the questions. If anyone does think of another question that was not addressed, please feel free to reach out and we'll be sure to answer any questions for you. Jess, can you go to the next slide for us, please? Thank you. All right, so here are some of SunRay's resources to help you stay organized and know your deadlines, secure your lien rights. So please go ahead and scan that QR code to access these incredible resources. There's a lot of really useful information on there for you. All right, and then the next slide, please. All right, our next webinar with Jess is going to be Wednesday, May 21st. That's don't sign a release until it passes this checklist. That's a really great webinar, so please join us for that. You can sign up for free at sunraynotice.com/education. We hope to see you there. And then the next slide, please. All right, if you don't mind, give us a quick review on Google. We really do appreciate any feedback you can provide to us, so scan that QR code for us. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Again, you are incredible, Jess. We really do appreciate you. I hope you all have a beautiful and wonderful sunny day. Thanks, everyone. Bye-bye.